Good morning, all. Welcome back to another class of CSEET Business Laws and Management by Excel Academy. Yesterday we were studying law of sale of goods, and today we'll be continuing the same. All right. I hope everybody is clear with all of the concepts that we've been discussing so far. And we also hope that you all have joined the WhatsApp group that Excel Academy has created, wherein you will be getting all of the notes and materials that we use in class, any important class related or even exam related updates for that matter. And if anyone is interested in a mentorship program, please feel free to contact us at this contact number. We would be more than happy to help you out, especially for the June 2026 program, wherein you have the new syllabus that is introduced, right? So please avail these benefits. And without further ado, let's begin with today's class. So yesterday we began with understanding what the law of sale of goods talks about, right? So we understood what is a contract of sale, what are goods, what is the price consideration, so on and so forth, right? Let's just do a quick recap. So we went through the contract of sale of goods, all right, wherein we understood that a contract of sale is where a seller agrees to transfer property to the goods to the buyer for what? For a money consideration called the price. All right. Then we understood the various essentials of the contract of sale, difference between sale and different types of contracts. So we had agreement to sell, risk and the risks and remedies in your sale versus agreement to sell. All right. Sale versus bailment, sale versus contract for work and labor, sale versus hire purchase, ownership and risk in your hire purchase. All right. So we went on to understanding goods, the different types of goods are there, what can be treated as goods, what cannot be treated as goods. All right. Yes. Then we proceeded with understanding perishing of goods. What happens if your goods perish before contract or after your contract? All right. What is your price? How is your price fixed? What happens when there's a third party who's required to fix price and they fail to fix it? All right. What is a reasonable price? Then we went on to understand stipulations, which are like basis of contract. So we understood conditions as well as warranty. All right. And then we saw various implied conditions and warranties that are there in the Indian Sale of Goods Act. All right. So I hope you have been able to understand all of these topics that we have discussed in class. All right. So now, without further ado, we'll begin with the next topics, which is your implied conditions. Okay. Implied conditions, starting with your implied condition to title. All right. I hope everyone is clear with whatever we have discussed so far. All right. If you have any doubts, please feel free to stop me and add your comments in the chat box below. I'd be more than happy to explain it to you. All right. Yes. Now let's begin with your implied conditions. We saw caveat emptor as well, wherein we saw that let the buyer beware, right? Like it is the buyer's responsibility to take care that they have examined the goods before they actually buy it. All right. And then we saw the different types of goods, and we ended the class with your passing of risk. All right. We ended the class with passing of risk. Okay. Next. The next topic that we have to start off today is your transfer of title by your non-owner. Okay, transfer of title by your non-owner. All right. Now, let's say, for example, A agrees to sell a phone to B. Okay, A agrees to sell a phone to B. All right. What happens in this case? When can A sell a phone to B, right? When A is the owner, right? When A is the owner, right? Only if A is the owner can he sell the phone to B, correct? And when B is purchasing the phone from A, right? B will automatically assume that A is the owner, right? Now let's say, for example, instead of A, C agrees to sell. C agrees to sell A's phone. Do you think this might be valid? Prima facie? No. Why? Because C is not the owner. Okay, C is not the owner. All right. What happens is that as per the Indian Sale of Goods Act, the basic or the general rule is that only the owner can sell your goods. Okay, only the owner can sell your goods. So in our example, who is the owner? A, right? Who is the buyer? B. But who is agreeing to sell the owner's phone? C. Do you think this is possible? No. All right. That's exactly what the general rule speaks about here, saying only your owner can sell your goods. All right. Sale by non-owner, no title to the buyer. All right. Let's say C agrees and goes ahead and sells A's phone to B. Okay. B will not get a good title. Why? Because the seller, that is C himself did not have good title to the phone. All right. So it is very, very important for you to understand that sale can be done only by the owner. Okay, that is the transfer of title can be done only by the owner. If at all it is not done by the owner, then the buyer will get no title. Okay, and the maxim which explains this is nemo dat quod non habet. Okay, no one can pass better title than he has. All right, so you can of course pass a title. To what extent? To the extent you have the title. Okay, if you do not have the title, you will not be able to pass it. Okay, so even if B believes that C is the owner and purchases it, B will not get the title to the goods. All right. So I hope I am clear when we say nemo dat quod non habet. All right. And seller cannot give better title than he possesses. Okay. Does C possess the title to the phone? No. Then he will not be able to give that title to B. All right. So the general rule is that only your owner will be able to transfer your title. Okay. If at all a non-owner sells it, the buyer will not get the title. And this is explained by the maxim which says nemo dat quod non habet. All right. Seller cannot give better title than of what he possesses. All right. So you will be able to sell anything to another person if you own it. Okay. If you do not own it, you will not be able to sell it. And even if a person purchases it from you, believing it that you are the owner, that person will not get a title. All right. So I hope you are clear with the concept, because next we'll be understanding the exceptions. Okay. So now what is effect? Even a bona fide purchaser gets no valid title. Okay. What is bona fide? Okay. What is bona fide? Someone acting in good faith. Okay, bona fide basically means someone acting in good faith. All right, that is, let's say for example, in this case, B completely was unaware that C is not the owner and in good faith has purchased the phone. All right, what happens in that case? Even then, they will get no valid title. Why? Because the seller C did not have any valid title. Okay, buyer of stolen goods, they have no ownership. Okay, let's say for example, a stolen car was sold to say B. Okay, then the original owner can come up to B and ask him to return his car. All right. So even though B had no idea that the car was stolen, B will have to return the car back to the original owner. Okay. Now, hirer under hire purchase sells goods. Okay. Now, in your hire purchase agreements, okay, so B hires car from A. Okay. Who is B? B is hirer, correct? Is he the owner? Not an owner, right? Until your last installment. Until your last installment. Why? What happens when there is a last installment? After last installment, if B goes ahead and purchases it, then he becomes the owner. But until then, he is just a hirer, right? So a hirer under the hire purchase, if B, suppose, say, sells this car to C, okay, C will not be able to become the owner of the car, only the hirer's interest, right? C can maybe rent the car, okay, but C will not become the owner of the car. Another example here is finder sells the lost ring, okay? Buyer gets no title. Let's say, for example, someone's ring was lost, okay? You picked it up, right? You did not try to find the finder. You went ahead and sold the ring, all right? Then in that case, the person, whoever bought the ring from you, will not get good title. Why? Because you were not the true owner. All right. However, exceptions to the general rule. What is the general rule? Only your owner can sell. Okay. And even if the purchaser is bona fide, they will not get good title. Okay. So now let us understand your exceptions to your general rule. That is cases where your buyer may get better title than the seller. All right. So first one, sale by mercantile agent. Okay. Before we even proceed to understanding it in detail, what do you understand in this case? Okay. So you have principal. Okay. And you have agent. Correct. What is principal? Principal is the owner of the goods and agent is just in the possession of the goods. Okay. What is our general rule? That only your owner can sell the goods and then the buyer will get good title. But in case of your agency, who sells the goods? Agent. Is he the owner? No. Right. So if the agent is in possession of the goods with the owner's consent, okay, that is if he has goods with the permission of the owner, okay, sells it in the ordinary course of business, right? Let's say, for example, you are dealing in, say, cosmetic products, right? So if you are selling cosmetic products that are owned by the principal in your regular course of business, and buyer acts in good faith without notice, buyer gets good title. Okay, buyer gets good title. Very, very important for you to remember that sale by agent is an exception to the general rule of that only owners have the right to transfer a title. All right. So I hope you are clear with this exception, wherein agent, although himself not being an owner, can go ahead and sell the goods in the ordinary course of business. All right. Sale by co-owner. Okay. Sale by co-owner. So let's say, for example, a car is owned by two sisters. Okay, car is owned by two sisters. That is, both their names are there in the registration. Okay, now in this, let's say two sisters A and B. Okay, A is in possession of the car. A is in possession of the car with B's consent. Okay, so if A goes ahead and sells the car, okay, and the buyer acts in good faith, the buyer will get good title to the car. Why? Because the car was co-owned by two people and it was in the possession of one person with the permission of the other. All right. So this is where, although both of them are the owners, even if one of the owner goes ahead and sells it, the sale will be valid and the buyer will get a good title. All right. Next, sale under a voidable contract. Okay, what is voidable contract? Let's go back to our Indian contract law, wherein we understood that it is, what is a voidable contract? It is enforceable at the option of a party. Okay, at the option of a party. Which party it is? It is the aggrieved party. Okay, it is your aggrieved party. Okay, it's not an aggrieved party, it is the aggrieved party. Yeah. Option of the aggrieved party. Okay, aggrieved party is who? The party who has suffered. Okay, so now let's say, for example, the seller is in possession under the voidable contract. Okay, contract has not been rescinded at the time of the sale. Okay, voidable contract means what? You have an option whether you want to continue with it or not. Okay, so in this case, your contract has not yet rescinded or cancelled. Okay, and then the buyer acts in good faith, the buyer will get your title. All right, it basically means that the seller, there's a voidable contract, the seller is in possession of the goods. Okay, the contract has not been decided, and if the sale goes through, then the buyer will get good title. Okay, next one, sale by seller in possession after your sale. Okay, that is, the sale has been done. Okay, sale has been done, but the seller has the possession. Okay, let's say, for example, there are certain bags of rice in your go down. Okay, those have been sold, but you still have the possession of it. Okay, now in that case, if the seller continues in possession and resells to the buyer, okay, resells to another buyer without notice of the previous sale, then the new buyer will get a good title. Okay, what happens in this case? Let's say sale has happened, all right, but the possession, okay, what happens when sale has happened? The ownership is transferred, but the possession of the goods is still with the seller. Okay, so if the seller sells these goods which are his possession to another buyer and that buyer acts in good faith, then he will get good title. All right, I hope you are able to understand these exceptions. To understand these exceptions, please make sure that you have understood the general rule properly. All right, next, sale by buyer in possession. Okay, sale by buyer in possession. Okay, let's say, for example, the buyer obtains possession with the seller's consent. Again, please pay attention to the fact that we are talking about possession and not ownership. Okay, let's say, for example, the buyer obtains possession with the seller's consent. Okay, then he resells it to a buyer in good faith without notice. Your buyer will get your good title. Okay, so if your transfer is pledge or pawn, it will be valid as pledge or pawn. All right, so in this case, what happens? The goods are in the possession of the buyer and he resells it to someone else, and the person to whom he is reselling it to will have good faith, and then this transfer will be valid. Okay, now coming to estoppel, this is a term we are coming across time and again. Okay, what is estoppel? Estoppel is holding out. Okay, holding out or allowing someone to believe something. Okay, we saw this in multiple cases. We had an agent by estoppel, right, in our Indian Contract Act, where we understood that someone shows themselves as an agent of another person. Okay, we had a partner by estoppel, where someone represents themselves to be the partner of the firm even that they are not. All right, estoppel sale is exactly what happens. That is, That is, the owner allows your buyer to believe that the seller has the authority, right? So they allow the buyer to believe that they have the authority to sell. Okay, then in that case, because the owner has allowed it, okay, the buyer will get good title. Okay, it can either be, let's say for example, you have owner A, buyer B, okay, and the person by estoppel is C. Okay, so who is actually the owner of the goods? A, all right. But what is happening in this case? C has represented himself to have the authority to sell the goods to B. Okay, C has represented himself to have the authority to sell the goods. Okay, C may not necessarily tell that I am the owner of the goods, but C may tell that, listen, I have the authority to sell these goods. Okay, in that case, the buyer will get good title. All right. So I hope you are clear with these concepts. Okay, clear with the concept of estoppel. Okay, sale by unpaid seller. Okay, sale by unpaid seller. Now this is an important topic which we will also be studying in detail a little later. So unpaid seller is someone who has not been paid the money even though they have completed their bunch of sale. Okay, now let's say for example, A agrees to sell car to B. Okay, B agreed to pay, B agreed to pay but has not yet paid. Okay, B agrees to pay but has not yet paid. Okay, which means that your payment is pending. All right, that makes A your unpaid seller. Okay, that makes A your unpaid seller. All right, that is, A has still not received the payment. Okay, so what happens in case of your unpaid seller? The seller will exercise lien or stoppage in transit. Okay, what is lien? The seller has a right to retain the goods. Okay, what is your lien? Seller has the right to retain your goods. Okay, or stoppage in transit. Okay, let's say your car is out for delivery. Okay, A has sent out the car to be delivered to B's place, but A has come to a notice that B has not made the payment. So A can stop the car in transit itself. Okay. So A becomes an unpaid seller when A has fulfilled his part of the obligation, but the buyer has not yet made the payment. In that case, the unpaid seller will have a lien, that is right to retain. A may either retain the car with himself, or if it is already sent out for delivery, they can order for a stoppage in transit. And someone like this can definitely resell your goods, and the second buyer will get your absolute title. Okay, second buyer can get your absolute title. All right. So I hope you are able to understand the cases wherein someone who is not the owner can also make the sale. Okay. Ideally, in this case, who is the owner? B. But did B make the payment to A? No. So what does that make A? A becomes your unpaid seller, and unpaid seller has a right to sell off the goods. So any person who is buying goods from an unpaid seller will get the absolute title to the goods. Okay. Next, you have your sale under other laws. Okay, sale under other laws. What happens in this case? Okay, so we have multiple examples saying that of a pawnee. All right, what is a pawnee? Now let's say for example you want a certain amount of loan. Okay, so then in that case you pledge your gold. Okay, you pledge your gold. Okay, saying I will pledge my gold, you please give me a loan of so and so amount. All right, what happens if you fail to repay that amount? Then the person with whom you have pledged it to can sell the gold. Okay, the person that you have sold it to can sell the gold. All right, let's just understand this with an example. Yes, so in case of pledge, okay, so A borrows money from B. Okay, A borrows money from B and pledges gold. All right, so A is the borrower. Correct. You have your A who is the borrower. Okay, and B is what? B is the pawnee. That is pawnee or pledgee. That is, you have pledged your gold with B. All right. Now what happens? A fails to repay the money. Okay. A fails to repay the money. Then in that case, B can go ahead and sell the gold. Okay. B can go ahead and sell the gold, and it is only in the case of default that this will be allowed. Okay, what is the default? That the person who has borrowed the money has not yet returned it. All right, the person who has borrowed the money has not yet returned it. And when has he not returned it? On the agreed time period. Okay, let's say if the gold was pledged for a period of 12 months, at the end of the 12 months you have not returned the money, then it's a default. The the bank, okay, or the pledgee cannot go ahead in the middle of those 12 months and go and sell it. No, it is very important that only on default the pledgee can actually go ahead and sell the gold. Okay, so does it make pledgee the owner? No, but does it allow pledgee to sell it? Yes. Okay, so the next example that we have is in the case of your finder of lost goods. Okay, finder of lost goods. So we are saying in some cases the finder of lost goods can sell the goods. Okay, when do you think this is possible? For example, in case of perishable goods. All right, so in case of perishable goods, if it is taking a lot of efforts to find the true owner, all right, and if the finder waits for any long, the goods might spoil or get rotten, then in that case it is completely okay for the finder to sell off your perishable goods. Okay, or else if he put in reasonable efforts and could not trace the owner, okay, could not trace the owner. Okay, in that case the finder can go ahead and sell the goods, and whoever is the buyer will get good title in your goods. All right, so I hope you have been able to understand both the case of your pledge as well as your finder of lost goods, and how they can sell the goods even though they don't own it. All right, next is your official assignee or receiver. Okay, official assignee or receiver, this is a person who is appointed on behalf of someone. Okay, that is, even though they might not own the goods, they will have a right to sell that person goods on behalf of whom they are appointed. Okay, liquidator is someone who is appointed at the time of your liquidation. All right, so at the time of liquidation, what happens in the time of your liquidation? So let's say, for example, liquidation. Okay, liquidation is basically a process of winding up or dissolution. Okay, your process of winding up wherein you're putting an end to the life of the company. All right, usually who manages your company? Your board of directors. Okay, and whom does the assets belong to? The assets belong to the company. Okay, the assets belong to the company. All right, but what happens in case of your liquidation? Your liquidator takes over. Okay, your liquidator takes over, and they will have a right to sell. They will have a right to sell the company's goods. Okay, so this is exactly what is meant by the seller not having the ownership but still having an authority to sell the goods. Okay, so liquidator is someone who takes over the responsibility and makes sure that all of the assets are realized, all of the liabilities are paid off before the company is actually dissolved. All right, so this is how your liquidator has a right to sell the goods even though he or she is not the owner. All right, and then you have the next example being that of your court officers. Okay, the next example being that of your court officers. So in certain cases, all right, when a person say becomes insolvent, okay, or when a person is arrested, a court officer is appointed to do the dealings on their behalf. All right, so let's say someone's bank account is frozen, right? So the court officer will have all the right to sell off the person's personal belongings, unfreeze the bank account, and utilize that proceed to pay off their liabilities. All right, and last one will be executors or administrators. Let's say, for example, when a person has passed away and has left a will, okay, so they will also appoint an executor who will perform as per the will mentioned by the person before their death. All right, so in all of these cases, if you notice, these people are actually not the owner of the goods, but they are able to go and sell the goods with complete authority, and whoever is the buyer will have good title to it. All right, so these are the exceptions to your general rule, which says that only your owner can transfer your good title in your goods. Okay, next, performance of your contract of sale. Okay, so now when is your contract of sale set to be performed? Okay, so firstly, it is your duty of the seller to deliver your goods. All right, So seller is the person, it is their duty to deliver your goods, correct? Then it is the duty of the buyer. Two things, okay? Firstly, they need to accept the goods as well. They need to pay the price for it, okay? Seller's duty is to make sure that they deliver the goods to the buyer. Buyer's duty is to make sure that they accept the goods and also pay the price, okay? Delivery and payment are concurrent conditions, that is simultaneous in absence of agreement, okay? That is irrespective of any additional conditions that are added. Delivery and payment is something that is understood by default, okay? So your seller is liable to deliver the goods, okay, and your buyer is liable to pay the goods, okay? So it is very important for you to understand, even if there is no express agreement of sale, okay? These are like implied or concurrent conditions that exist in every contract of sale, all right? Right. Now, let us move to the next one, wherein we understand delivery. Okay. Whose responsibility is it to deliver the products? It is the seller's responsibility to deliver the products. That is something that we just understood. All right. Now, let us understand the different types of delivery that are there. Starting with actual delivery. Okay. As the name suggests, the delivery is happening in actual. That is physical handing over of the goods. Okay. Seller hands the goods to the buyer. Okay. Let's say you go to a grocery shop and buy 10 kgs of dal. Okay. The seller is handing over the 10 kgs of dal to you immediately, right? That is what is actual delivery, wherein physical handing over. The delivery of the goods is given by whom? By the seller to the buyer. Okay. Constructive delivery. Okay, let's say, for example, you have bought the same 10 kg of dal, but you do not have your vehicle to take it at home. So you request the seller to keep the goods and you will come by the next day and pick up the goods. Okay, so in that case, what has happened? Ownership is transferred. You are now owner of the 10 kgs of dal, but you are still keeping it with the seller. Okay, so constructive delivery is where third party acknowledges holding goods for the buyer. Okay, it could be your packers and movers also. Okay, they could have your goods for today and get it transferred to you tomorrow, or it could be your seller as well who holds the goods as daily after sale. Okay, you did not pick it up after the sale was done, but you will say you picked it up after a day or two. So until then, your seller will be the bailee. Why? Because you have kept the goods with them. And the last one is your symbolic delivery, which means transfer of means of possession. Okay, that is, you are not actually giving the goods physical delivery. All right, you are giving something which symbolically represents that you have handed over the goods. Okay, let's say, for example, the 10 kg of dal is stored in a godown. Okay, so you are giving the keys of that godown to the customer. So that is a symbolic delivery. That is, you are not handing over the product that is actually sold, but you are handing over something that is a means to get to that product. All right, so I hope you are clear with the different types of delivery that are there. So who is responsible for delivery? Seller. What is the buyer responsible for? Accepting goods and payment. Okay, and when we speak of delivery, what are the three types of delivery? We have actual, we have constructive, and we have your symbolic delivery. Okay, now rules as to delivery. Okay, so when do we say that the goods are delivered? Okay, delivery must put your buyer in possession. Okay, now let's understand transfer of ownership is different from delivery. Okay, transfer of ownership, so transfer of title. Okay, when we say transfer of title, it speaks about ownership. Okay, and when we speak about delivery, it speaks about possession. All right, so please make sure that you are understanding the difference between these two. So when it comes to delivery, okay, your buyer should be in possession of the goods. Okay, the seller must deliver according to the contract. So why according to the contract is mentioned here? In some cases, the seller takes responsibility of the delivery. Okay, let's take a simple example itself. Let's say you are purchasing something online. Okay, you are purchasing something online from, say, Amazon. Okay, Amazon sometimes has two options wherein they will do the delivery, or you can even do a store pickup. Okay, if the store is nearby to you, you can even do a store pickup. All right, so if the contract at the time of placing the order, they have told delivery by so and so date, it means that Amazon itself will take the responsibility to deliver. But if you're saying store pickup, then Amazon will take the responsibility to keep the goods until you come and pick it up. All right, so the delivery will be according to the contract. Okay, seller delivers when the buyer applies. Okay, third party possession, delivery only on your acknowledgement. Okay, so sometimes your third party party can also possess. So maybe this store is not owned by Amazon, it is owned by someone else. That is what your third party possession is. Okay. Seller must tender your delivery properly. Okay. So Amazon, if they have agreed to deliver the goods, they need to make sure that the goods are reaching in good condition. It is reaching the right person and at the time that is promised. Okay. Goods must be in a deliverable state. All right. Let's say, for example, you have placed an order for a cake with a baker. All right, the cake is not set yet, and if you send it out for delivery, what will happen? The cake will collapse, right? So you should make sure, the seller should make sure that the goods are in deliverable state before actually starting with the delivery. Okay, if the seller must send goods, they must do so within your reasonable time. Okay, if no specific time period is agreed, you should do so within a reasonable time. All right, let's say the buyer has requested for a cake but they've not given the date. All right, so you should, depending on the facts of the case, saying for what event do they want the cake, or if facts are also not available, reasonable time. How many days would you store a cake for? Say 2 to 3 days, right? You would not say deliver it after a week or so, right? So it is very important for you to understand what is reasonable time depending on the scenario. Continuing to understand the rule of delivery, okay, the place of delivery will be either as per the contract or where your goods exist or are produced. Okay, so the delivery should be at proper place, working hours, and working day as well. Okay, now who bears what cost? Okay, so your seller will usually bear the cost of delivery, buyer will bear the cost of receiving your delivery. Okay, depends on the situation. Seller has to bear the cost to make your goods deliverable. It is the seller's responsibility to make sure that before the goods are actually delivered to the customer, it is in a deliverable state. Okay, now, if delivery is elsewhere, your buyer will bear your risk. Okay, buyer is not bound to accept installments unless agreed. Okay, so if your contract specifically tells that in your 10 kgs of dal, we will deliver say 2 kg each day for 5 days, it is not acceptable. But if the buyer has agreed to it, then it is completely acceptable. All right. So I hope you have understood the meaning of the delivery and what are the various rules of delivery that are applicable in your contract. All right. Now, next comes acceptance of goods. Okay, so we saw three things. Seller has to deliver, buyer has to accept and also pay the price. All right. So now let us understand from the buyer's point of view with respect to your acceptance. Okay, so your acceptance occurs when your buyer, okay, when your buyer expressly accepts your good, okay, expressly accepts your goods, retains goods beyond your reasonable time. Okay, expressly accept the goods. Okay, let's say for example you have ordered something on Mintra, the delivery person has come to your doorstep and you have accepted it. Okay, you are accepting your goods, retain goods beyond reasonable time. Okay, let's say for example Mintra told that your return window is for 7 days. Okay, return window is for 7 days, but you have retained it for 8 days now, which means that I have retained it beyond the reasonable return time of 7 days. All right. And now acts inconsistent with the seller's ownership. Okay. It means that I have gotten the goods, I have already either resold it to someone else or I have given those goods on pledge. What does that mean? That makes me the owner, which makes the seller believe that I have accepted the goods. All right. So once the seller's responsibility of delivery is done, it is on the buyer to accept the goods. Okay, so you can either expressly accept your goods, or if you have retained it beyond a reasonable time, you have said to be accepted, or you act inconsistent with the seller's ownership. This is not wrong, but this is an indicator that you as a buyer have accepted your goods. Okay. Next, delivery of your wrong quantity. Okay, delivery of your wrong quantity. What happens? You had ordered your 10 kgs of dal. Okay, now what happens if excess or less? Instead of 10, say they have given you 2 kg, or instead of 10, they have given you 15 kg. Okay, you can either reject the whole, saying I do not want either of it. Okay, you either give me 10 kgs or do not give me at all. You can accept the whole. Okay, that is, you can accept the 15 kg. Okay, accept current quantity and reject the rest. Okay, so you can accept 10 kg and return the 5 kg extra which has been done. All right, so it is up to the buyer to decide what do they do when the goods have been delivered with a wrong quantity. All right, Yes, apologies. There was some technical error. All right. Yeah. I hope you all are able to see the screen. Yes. I will just reshare the screen. Please allow me a minute. All right, great. So now, goods of wrong description. All right. So we were seeing wherein in specifically, if you had mentioned you wanted basmati rice, but the seller has delivered, say, 5 kg of your basmati rice, 5 kg of any other rice. So what you may do, you may either accept this 5 kg and reject this, or you may reject the entire one and request specifically for 10 kgs of your basmati rice. All right. So it depends on you as the buyer. How do you want to go about with these goods? Okay. Next. Installment deliveries. Okay, installment deliveries. Let's say, for example, you have subscribed for milk. Okay, for milk, saying 1.5 liters every day. Okay, 1.5 liters per day. Okay, so in goods delivered in installment with separate payment. Okay, goods in delivered in installments with separate payment. If there is any breach in this, okay, if there is any breach in this, the buyer may repudiate the whole contract. Okay, let's say, for example, today your 1.5 liters was not delivered. So what can you do? You can repudiate the whole contract itself, saying starting tomorrow we do not want the milk. Okay, or be severable. That is, for today, whatever damage has been caused, please compensate for that. Okay, depends on the terms of your contract as well. Now, what happens when there is a breach of contract? Okay, what happens when there is a breach of contract? Okay, seller may sue for price. Okay, seller may sue for price. So when we are saying breach of contract, we are saying when the buyer has done some breach of contract. Okay, seller may sue for price when the property has passed on to the buyer. Okay, that is, if the buyer has already become the owner, then the seller can sue for price, saying because the property has already been transferred to you, please pay us the amount for the property. Okay, when the price is payable on a fixed day irrespective of a delivery. Okay, let's say, for example, in our milk example itself, you want your 1.5 liters to be delivered every day, but the price for that you have already paid in the beginning of the month. Okay, so in that case, or it is to be paid towards the end of the month, in that case your seller can sue for your price. Okay, seller may sue for damages for non-acceptance. Okay, let's say, for example, what happened is you bought a laptop, or let's say you bought a TV. Okay, and then the seller has come to your house to deliver the TV. All right, and at the time of delivery you refuse to accept the TV. Okay, seller would have incurred some charges to get the TV in up and running condition to deliver it to your house and also install the TV. All right, so that is the case wherein your seller can sue your damage for non-acceptance, saying for the delivery we have spent so much amount, so now we are going to recover the damages for non-acceptance. Okay, so that is when your buyer refuses to accept or they neglects to accept and pay. Okay, next is buyer may sue damages for non-delivery. Okay, that is, if the seller has not delivered it within the time period or within the time period agreed as per the contract, then the buyer can sue for damages for non-delivery. All right. Next is in breach of warranty. Your buyer cannot reject your goods but can claim reduction in price or damages. If loss is greater than the price, then you may sue it for damages. Okay. If the buyer has paid but the goods are not delivered, there are two things that you can do. Okay. You can either recover the price that is paid or may get court order for delivery of specific goods. Okay. So this is when it comes to bigger items. So let's say, for example, if you use your quick e-commerce platforms, right? Like say your Blinkit, Swiggy, Instamart, or Zepto. In that case, let's say you have ordered 10 items and one item is not delivered. Okay, so when you reach out to their customer support, they will give you two options. Okay, one is that we will either refund the amount for that one particular item, or if you want delivery, we can do the delivery as well. So it is at the buyer's discretion that if they feel that they do not want that product and a refund is okay, then they can recover the price that they have paid, or they can specifically request delivery of those goods. All right, so this is what happens when there's a breach of contract and how filing of suits work in both the cases, when there's a breach from a seller's end as well, breach from the buyer's end as well. All right, now Anticipatory breach, okay, that is repudiation before the date of delivery, okay, before even the goods are delivered, you are repudiating the contract, okay. So aggrieved party, okay, whoever is the affected party may treat the contract as continuing. The default party retains the right of the performance and can raise defenses arising after repudiation, okay. And they may also treat the contract as rescinded and sue for damages, all right. So even though the delivery has not happened, the aggrieved party may retain the right of the performance and can also rescind or cancel the contract, okay. Rescind is basically cancel your contract, okay. Then, measure of damages. So the act does not specify the rules as to how your damages can be measured. So you have the right to recover your interest and special damages, which will be as per section 73 of your Indian Contract Act. All right. Now, next is the concept of the unpaid seller. But before we proceed to this, let's quickly go back to the module and have a look at what we've studied and discussed so far. Okay. So we started off with the concept of transfer of title by the person who is not an owner, right? So what is the general rule? General rule is that only the owner can sell the goods. Okay. And what is the maxim? The maximum is nemo dat quod non habet. That is, no one can pass a better title than he himself has. All right. Now, in case, let's say, for example, A is the hirer of goods under hire purchase agreement, sells them to B, and B is a bona fide purchaser. What is bona fide purchaser? Someone who has purchased in good faith, okay? They do not acquire the property in the goods, even though B had purchased in good faith, okay? A finds a ring of B and sells it to a third person who purchases it for value and good faith, okay? But even though that person has purchased it for good faith, the original owner, okay, that is B, can recover from that person, all right? Next, exceptions to general rule. We saw your mercantile agent, your co-owner, the person in possession under a voidable contract, your seller in possession after your sale, sale by a buyer in possession. Estoppel is someone who represents themselves to have authority to sell the product. Yeah, sale by an unpaid seller and by persons under others. Okay, so you have your pawnee, you have your finder of lost goods, official assignee, liquidator, officer of court, executors, and administrators. Okay. Then we speak of your performance of your contract of sale, wherein they have both the duties, that is, duty of the seller is to deliver the goods, whereas duty of the buyer is to accept the goods and pay for them. All right. So delivery is the voluntary transfer of possession from one person to another. All right. This is very important, wherein delivery is the voluntary transfer of possession from one person to another. So it can be actual, constructive, or symbolic. Okay. Actual is physically you are handing over goods. Then you have physically handing over the goods. Okay. Constructive is when the person acknowledges that the goods are held on his behalf. That is when a third party is holding goods for them. And symbolically is giving a means of obtaining your possession. That is your keys to your go down. Okay. What are your rules to your delivery? That is, buyer should come in possession. It should be as per the contract. Okay. The duty, the seller is to deliver the goods when the buyer applies to delivery. Okay. Where the goods at the time of sale are in possession of the third person, there will be delivery only when that person acknowledges to the buyer that he holds the goods on his behalf. Okay. That is, the goods, suppose he may not be at his go down, but someone else's go down, but he has acknowledged that yes, I will be sending it to you from the other person's go down. Okay. So the sender also should tender delivery so that the buyer can take the goods. Okay. It is no duty of the seller to send or carry the goods to the buyer unless the contract so provides. Okay. Then you have the place of delivery, which is usually mentioned in your contract itself. That is, the goods must be delivered at the specified place during working hours on a working day. All right. Where no place is mentioned, it is to be delivered at the place which they happen to be at the time of contract of sale. And if not, okay, so let's say you purchased a washing machine and you have not specified the person as to where you want the home delivery to be. So in that case, what the seller will do, they will keep the washing machine ready at the showroom itself, and it'll be your responsibility as a buyer to go and pick it up from the showroom. Okay. Next, seller has to bear the cost of the delivery. Okay. Seller has to bear the cost of the delivery. That is, obtaining delivery is that of the buyer. Okay. Let's say if the buyer has agreed to obtain the delivery, the cost will be on the buyer, but otherwise the seller has to bear the cost. Okay. If goods are delivered a place other than where they are supposed to be delivered, then the risk of deterioration in transit will, unless otherwise agreed, be borne by the buyer. Okay. And buyer is not bound to accept delivery in installments unless otherwise agreed. Okay. So what was the agreed example that we saw? Delivery of your milk. Okay. Now, acceptance of the goods. Okay. When do you think the buyer has said to have accepted the goods? Okay. So there are various scenarios. First one, he intimates. He specifically expressly communicates to the seller saying, I have accepted. Okay. He retains the good or does any act which is inconsistent with what? With the ownership of the seller. All right. If the seller sends the buyer a larger or smaller quantity of the goods, okay, buyer may reject the whole, accept whole, accept correct and reject the remaining. Okay. And if seller delivers with the goods order goods of wrong description, the buyer may accept the goods and correct goods and reject the rest, or they can reject the whole as well. Okay. When now next one is your installment deliveries. When there is a contract for sale of goods to be delivered by stated installments, which are to be separately paid for. Okay, separately paid for, and either the buyer or seller commits a breach of contract, then it depends on the term of contract. Okay, whether the breach is a reputation of the whole contract or merely giving a right to claim your damages. Okay. Next is your suits for breach of contract. Okay. When property has passed, the seller may sue the buyer for price. Okay. When price is payable on a certain day, regardless of the delivery, the seller may again sue for price. Okay. Where buyer wrongfully neglects or refuses to accept, the seller will sue the buyer. Okay. Where seller wrongfully refuses to deliver, the buyer can sue the seller. Okay. Where there's a breach of warranty. Okay. And the buyer elects to treat the breach of condition as a breach of warranty, the buyer cannot reject the goods. Okay. Again, something which is very important. He can set breach of warranty in extinction or diminution of the price payable by him. And if the loss suffered is more than the price, then he may sue for damages. Okay. Damages is nothing but your compensation. Okay. Then we had anticipatory breach, wherein it has happened before the date of delivery itself. The other party may either treat the contract as still subsisting and wait till the date of the delivery, or he may treat the contract as rescinded, that is, cancel the contract and then sue for your breach. Okay. In case the contract is treated as still subsisting, it would be for the benefit of both parties and the person who had originally repudiated, that they will not be deprived of right to performance. Okay. And his right to set up any defense for your non-performance. Okay. Now, how your measure of damages. Okay. So Act does not provide for any specific rules with respect to your measure of damages, except by stating that nothing in the Act shall affect the right of the seller or the buyer to recover interest or special damages in any case where by law they are entitled to the same. Okay. So whatever damage has been caused, they can recover that, but there's no measurement that the sale of goods Act specifically gives you. So what you will do, you will refer to the section 73 of your Indian Contract Act. All right. That is exactly what we saw in the beginning as well, when we were understanding the applicability of Sale of Goods Act, that you will study it in relation to your Indian Contract Act. All right. So I hope you are clear with all of these topics that we have discussed so far. Now, next up, we will be understanding the next important concept, which is that of your unpaid seller. Okay. Unpaid seller, we just briefly discussed it, is a seller to whom the price has not been paid. Okay. So who is an unpaid seller? It is given in section 45 of which act? Your Sale of Goods Act of which year? 1930. Okay. So seller is unpaid when the whole price is not paid or tendered. Okay. Whole price is not paid. Conditional payment by your bill of exchange or negotiable instrument is dishonored. Okay. So we have already understood what a negotiable instrument is earlier. We have the next chapter which speaks entirely about a negotiable instrument. So we will understand this in detail there. But for now, what you need to understand is a seller is said to be an unpaid seller if the buyer has not paid the price to the seller. Okay. Rights of the unpaid seller, that is right to lien. Okay. What is your right to lien? Right to retain your goods. Okay. So the seller may refuse to complete the delivery of the goods unless the buyer has completed the payment. Okay. Right of stoppage in transit, the seller has already sent out the goods for delivery, but then the buyer has still not paid. The seller can stop the goods in transit. Okay. Right of resale, if beyond a reasonable amount of time the buyer does not pay at all, the seller can very much sell that product to someone else. Right to withhold delivery, not start delivery itself. All right. So the law protects your unpaid seller. That is, if the buyer has not paid the amount to the seller, then the seller can have a lien. That is, they can retain the products, stop the products in your transit, either resell it or even withhold delivery. Okay. Next, First one is your right of lien. Okay, so right of lien specifically talks about retaining your goods. Okay, right of lien specifically talks about retaining your goods. That is, refuse your delivery until your price is paid. So they are not canceling the contract, they are just withholding the delivery. Why? Because the buyer has not paid the price. Okay, so what are conditions for lien? Goods sold without credit. Okay, without credit. What happens when there's a credit? Okay, so what is an unpaid seller? Like, let's say you purchased a refrigerator, you had to pay 70,000 rupees at the time of the contract. Okay, but you have not paid. Okay, then that makes an unpaid seller. But let's say you purchased a washing machine for 70,000 and agreed to pay a month later. All right, then they will not be said to be an unpaid seller. Why? Because the contract specifically says that the payment will be made after 1 month. So unless that period of 1 month is expired, you cannot be an unpaid seller. Okay, or if it is given on credit, your credit period has expired, like the 1 month that we just spoke about. And if your buyer becomes insolvent. Okay, nature of lien depends on physical possession, that is your possessory lien, only for price and not other charges. Okay, only for price, that is your lien will be to the extent of the price of the goods. Okay, now when is a lien lost? Okay, when goods are delivered to carrier. Okay, what is lien? You have the right to retain the possession of the goods. Okay, lien specifically means that you have the right to retain what? Retain possession. Okay, but if you have given goods to the carrier, okay, who is the carrier? Any mode of transport that you have appointed to say deliver of goods. Okay, so if you have given the goods to your carrier, then in that case your lien will not be there. Why? Because your physical possession has gone away to the carrier. Okay, buyer or agent obtains the possession and seller voluntarily waives the lien. Okay, so I hope you are clear with the concept of your lien, which is the right to retain the goods until the buyer makes the payment. Okay, so this is the first one. The second one is stoppage in transit. Okay, that is resume possession. That is, you have already sent it out, but you have resumed your possession. That is, you have got back the possession and you have said that you will retain it until the price is actually paid. Okay, then your condition is your that the buyer becomes insolvent and the goods are in transit. Okay, that is, if the buyer becomes insolvent and is not in a position to pay you, then in that case you have a right to stop the goods in transit. Okay, that meaning of insolvent, we've seen this time and again, but it is someone who cannot pay debts as they become due. Okay, not necessary to be declared insolvent by the court. Okay, next, stoppage in transit, rights and effects. Okay, mode of exercise. So what can the seller do? Okay, the seller can take your actual possession. Okay, or give notice to carrier and bailee. Okay, so who is the carrier? The person who transports the goods. Okay, so they can tell the carrier that, listen, instead of delivering it to the buyer, can you return it here to my address? Okay, so that is, carrier must re-deliver the goods and seller must pay redelivery expenses. Why? Because the seller has specifically exercised his right to stoppage in transit. Okay, effect on subsequent sale. Okay, seller's rights not affected by buyer's resale, wherein the exception is that transfer of bill of lading or document of title to bona fide purchaser for value, it is valid against the seller. That is, if someone has purchased these goods for a good faith, in a good faith, then it will be valid. Okay, next, duration of transit and when it ends. So when are the goods said to be in transit? Okay, from delivery to the courier and until the buyer actually takes the delivery, that's when your transit ends. Okay, transit ends when buyer obtains delivery. Okay, courier acknowledges holding goods for the buyer, which means that buyer has said, yes, these goods are now mine, but until this so and so time, the courier will hold it. Okay, courier wrongfully refuses your delivery, and if buyer reject goods, your transit will continue. All right, so I hope you have been able to understand the concept of your transit here. Okay, next, right of resale. Okay, so unpaid seller may resell your goods if the goods are perishable, right? If right of resale is expressly reserved and seller gives notice of resale plus buyer fails to pay. Okay, so let's say in different cases, what happens if your goods are perishable, right? Then you will not wait for the buyer to pay you the money. You would rather sell it to someone else and get the money immediately. Okay, and here notice of resale. Let's say, for example, if it's a bigger object, okay, let's say a car, okay, but the buyer has not paid. So you give a notice to the buyer saying, we might put it up for resale. If required, you please make the payment between so and so date. Okay, so now what happens in resale? if there's a deficiency. Okay, if there's a deficiency, if the price was actually say 20,000, but you have received only 15,000, okay, then the remaining 5,000 you can ask it from the buyer. Okay, but let's say I have sold it for 25,000, so the excess 5,000 I can keep it with myself. Okay, if no notice is given. Okay, what notice? Notice of resale. Okay, so what notice are we talking about? We are talking about your notice of resale. If no notice is given, your seller cannot recover any loss. Okay, your seller cannot recover any loss and must pay profit if any to the buyer. Okay, so must pay the profit if any to the buyer. Why? Because the buyer is supposed to be the owner of the goods. All right, so I hope you are understanding the concept of unpaid rights that they have. Next is also the right to withhold your delivery. Okay, so if property has passed, rights of lien, stoppage, and resale apply. If property has not passed, okay, which means that the delivery is yet to be done. Correct? Delivery yet to be done. So in that case, your seller can withhold your delivery, and this right is similar to lien and stoppage in transit itself. Okay. Next, rights against your buyer. Okay, rights against your buyer. So the seller may sue for price. Okay, when the property has passed and price is payable on a fixed delay. So this is something that we've already gone through earlier. That is, property is already passed. There's no way you can withhold the property with you. All right, then you can sue the buyer for a price. Seller may sue for damages when buyer does not accept, and rights against the buyer personally will be for suit for price and damages both. Okay. Now, next is the case of your auction sale. All right. So in auction sale, we have understood. So now we have completed the concept of the unpaid seller and we are moving to the next concept of auction sale. Okay, now what happens in your auction sale? So there will be a object. Okay, let's say for example it is an antique furniture auction sale. Okay, so you will display each of the object. Okay, and the sale will be completed upon the fall of the hammer, right? So you have the auctioneer who has a hammer. All right, and in that case, if the auctioneer hits the hammer on the head on the table, and then in that case it will be said that the product is sold to the person who has done the highest bid. Okay, the item will be sold to the person who has done the highest bid. All right, if please allow me a moment. Yes, thank you for waiting. So, auction sale is when the object is sold to the person who has placed the highest bid, and the sale is represented by a fall of the hammer. By whom? By the auctioneer. Okay. So, it is a public sale. Why? Because numerous a number of people are actually participating in the sale. All right. Each lot is a separate contract. So, every single item that you are selling is going to be a separate contract. Okay. Sale happens when? On the fall of the hammer. Bidder may withdraw the bid before completion. That is, before the fall of the hammer, they may withdraw it. Once the hammer has fallen down, it means that you have sealed the contract. Okay. Seller may bid if right is reserved. Okay. If no such right, seller cannot bid. Okay. Seller cannot bid. If there's a violation, then it will be considered to be a fraudulent sale. Okay. Seller may have reserve price as well. That is, this is the minimum price that we are going to accept for this. Bid below the reserve price, no contract. All right. So sometimes you see in case of these articles, right? Let's say your antique furniture. So in that case, they specifically mention the starting bid price. Okay. Pretended bidding, sale is voidable at the buyer's option. Okay, that is, they were not pretending actually, but just for the sake of it. All right. So even your IPL auctions, for that matter, right? If you have ever seen an IPL auction, you will be able to see sometimes you add a base value to the player. All right, to make sure that you are paying a fair price to have them on your team. All right. So that is where there is a reserve price saying at least minimum this is the amount that you have to pay to secure this player in your team. Okay. So I hope you are clear with the concept of your auction sale. Next comes in the trading contract, specifically with respect to your rail or sea transit. Okay. So now we have these terms. Let us understand this one by one, and then we would reach the conclusion of this chapter. All right. So now, what is free on board? Okay, so seller loads the goods on ship at their own expense. Okay, so when we are saying free on board, it means that the seller's responsibility to load the goods on the ship and also make the payment for them. Okay, the property passes when the goods are on board. So once the goods are on board in the ship, the property will pass. To whom will it pass? It will pass to the buyer. Okay, so risks will be of the buyer after loading. Why? Because the property has passed after you are on board. Okay, seller must notify the buyer that listen, now the now the goods are on the ship. Okay, if not, the risk remains with the seller. Okay, so what does the concept of free on board? Okay, so free on board is in the case of your ship, free on rail is in the case of your trains. Okay, so both the things, the concepts are the same. Okay, so it is the responsibility of the seller to load the goods. Once the loading is done either on your ship or your rail, the property passes to the buyer. Anything that happens, that it is the buyer's responsibility, provided the seller has given a notice to the buyer. All right. So I hope you are clear with the concept of your free on board and free on rail. Then as we move further, we have your cost, insurance, and freight, which all of the three are borne by your seller. Okay. So cost, insurance, as well as the freight as well. All three of these expenses are borne by the seller, and insurance is for the benefit of the buyer. Okay. So cost of getting the goods, cost of transportation, cost of insurance, all of these costs are borne by the seller. Okay. Buyer pays on any documents. If buyer can also reject the goods if they are not as per contract. All right. And X ship. Okay, X ship, in this case, the seller delivers goods to the destination port. Okay, what happened in case of your FOB? Okay, what happens in the case of your FOB? Your seller's responsibility is until your loading. Okay, your seller's responsibility is until your loading. But in case of your X ship, okay, your seller's responsibility is until destination. Okay, is until your destination. So which means that it is not only loading. Okay, it is not only loading but also transportation. Okay, but also your transportation. All right, which means that seller will deliver the goods to your destination port. Okay, your buyer will pay when goods are ready for unloading. Okay, so in our free on board, seller's responsibility was only till loading, but in X ship it is until unloading. Unloading will be taken up by the buyer. Okay, so risk, it is that of the seller during transit. Why? Because they have it until unloading. Seller is not bound to insure for your goods, but in the case of your CIF, your seller is bound to insure for your goods. All right, so I hope you are clear with all the three examples, that is your free on board, free on rail, cost, insurance, and freight, as well as X ship. All right, so with this we come to the conclusion of your Sale of Goods Act. All right, before we take a quick break to start the next chapter, let us go through the module to see all of the topics that we have discussed so far in your Sale of Goods Act. All right. Yes, so we started off with your unpaid seller. So who is an unpaid seller? So that is when the whole of the price has not yet been paid, okay? Or when a conditional payment was made by a bill of exchange and the instrument has been dishonored, okay? That is either the buyer has not paid the payment itself, or else a conditional payment was made and the negotiable instrument through which the payment has been made has been dishonored, okay? What are the rights of an unpaid seller? Okay, right of lien, that is the right to keep the goods, that is retain the goods. Okay, that is refuse the delivery to the buyer until the fulfillment of the tender. Okay, so goods have been sold without stipulation as to credit. Okay, you have sold it on credit, but the term of credit has expired and the buyer becomes insolvent. Very, very important to understand that lien depends on your physical possession. Okay, that is your seller should have the physical possession of the goods, only then the lien is done. When is your lien lost? Okay, when it is given to the carrier. Okay, when the buyer obtains the possession, or the waiver specifically says that I do not want this lien. All right, next is your stoppage in transit. Okay, transit is your period of delivery. Okay, or the in-process delivery. Okay, so the right of stoppage in transit is a right of stopping the goods while they are in transit, resuming possession. So first you stop the delivery to the buyer, okay, then you regain the possession, okay, and then you retain it as well until the price is paid. Okay, when will this right be available? When the buyer becomes insolvent or when the goods are in transit. Okay, the buyer is insolvent if he has ceased to pay the debt. So this is just the meaning of your insolvency. The goods are in transit from the time they are delivered to a carrier or other bailey like a wharfinger or warehouse keeper for the purpose of transmission and until the buyer takes delivery of them. All right, so it is either you can directly deliver the goods to the buyer, then it will be in transit, or if you're giving it to a carrier, from the time it has left your space to the courier space, from the courier to the buyer, it will be in transit. Okay, when does the transit comes to an end? When buyer obtains delivery. Okay, carrier acknowledges that they are holding the goods only on the buyer's behalf and the carrier wrongfully refuses your delivery. Okay, and if the goods are rejected by the buyer and the carrier or the other baileys hold them, the transit will deem to continue even if the seller has refused to receive back. Why? Because the goods have not yet reached the buyer. The transit is said to be complete when your goods reach the buyer. Okay. The right to stop in transit may be exercised by the unpaid seller either by taking actual possession of the goods or by giving notice to the seller's claim to the carrier or other person who has the control over the goods. Okay, then we saw our right to resale. Okay, so when your goods are perishable, when this right is specifically mentioned in contract, okay, the seller has to give a notice to the buyer of the intention to resell. Okay, then you have your right to withhold delivery. That is, if the property in goods has passed, the unpaid seller has right as described above. Okay, however, if the property has not passed, okay, then the unpaid seller has a right of withholding the delivery. Okay, rights of an unpaid seller against the buyer. Okay, they may sue the buyer for what? For price of the goods in case of breach of contract where the property is passed. Now the buyer already has the property, the only thing the seller can do is get the price. Okay, or he has wrongfully refused to pay the price. The seller may sue the buyer even if the property has not passed. Okay, then under section 56, the seller may sue the buyer for damages or breach of contract where the buyer wrongfully neglects or refuses to accept to pay for the goods. Okay, this is something that we've seen earlier. Okay, you can the seller can sue for both price as well as damages. All right, then you have the concept of your auction sales. All right, wherein it is a public sale where goods are offered to be taken by your bidders. Okay, so it is a proceeding at which people are invited to compete for the purchase of a property by successing offering of advancing sum. What does advancing sum means? Increasing sum. Okay, if one person has bid say a certain amount, the next bidder will quote a amount higher than the first bid. All right, Section 64 lays down the rules with respect to your auction sales, right? So it says where the goods are put up for sales in lots, each lot is prima facie a separate contract itself. Okay, when is the sale complete? By fall of the hammer. Okay, until such announcement, any person may retract his bid. So once the fall of hammer is done, no person can retract your bid. Until that, the person can retract the bid. All right. Then a right to bid may be reserved expressly by or on behalf of the seller. Okay, so where such right is reserved, the seller or any other person in that behalf may bid at the auction. Okay, so the seller can also bid at the auction. All right, so this is something that we have already seen and discussed. Okay, if you have any doubts, please let us know. Then you have trading involving rail or sea transit. So we have free on board where it is the duty of the seller to put the goods on the board at their own expenses. Okay, the property will pass after the goods are put on board in the ship and the seller notifies the buyer. Okay, free on rail is a similar concept, but instead of ship, you have it for your rail. Okay, CIF is your cost, insurance, and freight. That is a contract for sale of insured goods, lost or not lost, to be implemented by a transfer of your proper documents. All right. Next, in such type of contract, the seller not only bears the expenses of putting the goods on board, okay, but also the freight and your insurance charges. Okay. Insurance of the goods is for the benefit of the buyer. Then on the tender of all of these documents, the buyer is required to pay and then take delivery. Okay. He has the right to reject the goods if they are not according to your contract. And the last one that we saw is ex-ship, where not only until loading, but also in transit and until unloading, the seller is liable. Okay, so here the seller is bound to arrange the shipment of the goods to the port of the destination and to such further inland destination as the buyer may stipulate. Okay, the buyer is not bound to pay unless the goods are ready for unloading from the ship. All right, so I hope you are clear with all of the concepts that we have discussed in our Sale of Goods Act, both yesterday as well as today. So with this, we come to an end of the chapter of your sale of goods. All right, before we proceed and begin with the next chapter, let's quickly do a lesson roundup and then take a break. All right, so the law relating to sale of goods is contained in which act? Your Sale of Goods Act of 1930. Okay, it has to be read as a part of your Indian Contract Act 1872. All right, we just saw your measure of damages, that it is there in the section 73 of the Indian Contract Act, which means that if Sale of Goods Act specifically does not mention anything, you may take reference from your Indian Contract Act. Okay, so what is a contract of your sale of goods? Okay, where the seller transfers or agrees to transfer. So this becomes a sale, this becomes an agreement to sell property in goods to the buyer for a money consideration called the price. Bilateral contract, two people should be there. Transfer of property, subject matter is goods. There has to be a price. If there is no price, it will be a gift. Or if there's a product in exchange for another product, it's going to be a barter. Okay, all essential elements must be present, right? In sale, your property in goods passes to the buyer at the time of the contract so that he becomes the owner. Okay, so when we are talking about the property in the goods, we are talking about ownership and not possession. Okay, in an agreement to sell, the ownership does not pass at the time of the contract, but only at the end of the specified period when the agreement was sale was supposed to be done. Okay, where goods are delivered to another on the terms which indicate that the property is to pass at once, the contract must be of sale and not of bailment. Okay, so we understood the difference between sale and bailment. Then we understood hire purchase agreement, wherein you hire, wherein the end you have an option to purchase at the last installment. Okay, subject matter of your contract of sale is usually your goods, which is every kind of movable property, but does not include what? Actionable claims and money, but includes stocks and shares, growing crops, grass, and things attached to the land, which will be severed before your contract. Okay, goods may be existing, future, contingent. Existing also you have specific, generic, ascertain or unascertain. Okay. No sale can take place without a price. Price is nothing but the money consideration that is an essential of the contract of the sale. Okay. Now, who fixes the price? It can either be fixed by the parties at the time of contract, either through the course of dealings, okay, some way stipulated in the contract, or maybe fixed by a third party. Okay. Now the parties are at a liberty to enter in the contract with any terms as they may please. Okay. Before a contract, certain statements are made by the party to each other. That is nothing but your stipulation, wherein you have both condition as well as your warranty. Okay. Condition is something that is the main purpose. Warranty is something which is collateral to the condition. Okay. The sole purpose of a sale is the transfer of ownership of goods from the seller to buyer. Okay. General rule is the owner can sell the goods. So this is where we started off discussing today. Okay. Conversely, the sale of an article by a person who is not or who has the authority gives no title. Okay. Now it is the duty that the contract should be performed. Seller's duty to deliver the goods, buyer to accept the goods and pay for them. Okay. Unless otherwise agreed, payment of price and delivery of goods are concurrent conditions. That is, they take place both at the same time, especially in the case of a cash sale over a shop counter. Okay. Delivery is what? What is the meaning of delivery? Again, very important. Voluntary transfer of possession from one person to another, where it can be actual, you are actually transferring the goods. Constructive, you are giving it to a third person. Symbolic is you're merely giving the means of possession. Okay. Acceptance is when buyer intimates the seller that they have accepted it, retains the goods beyond a reasonable point of time, does anything which is inconsistent with the ownership of whom? Of the seller. Okay. Then The seller of goods is deemed to be unpaid seller when whole of the price has not been paid, okay, and when there was a conditional payment with a negotiable instrument and that was disordered, okay. An unpaid seller, right of lien, that is retaining possession. Stoppage in transit, that is stop, transmit, and regain the possession. Right of resale, resell it to someone, say when it is perishable or they specifically have that right. And withhold delivery. If it has not yet been delivered, you withhold it, okay. A sale by auction is a public sale where your goods are offered to be taken by the highest bidders. It is complete by the fall of the hammer. So until then, your bids may be retracted, okay. Your simple glossary to understand here. Bilateral contract is an agreement formed by an exchange of a promise in which promise of one party is the consideration supporting the promise of the other party, right? So promise of one party is consideration. I will pay you 50,000 rupees if you sell this car to me, okay? Then goods, what is the meaning of goods? Every immovable property other than what actionable claims and money, and includes your stocks, shares, growing crops, grass, and other things attached to land which are agreed to be severed. Please make sure that not all things attached to land are your goods, but only those which are agreed to be severed before your sale. Okay. Then you have existing goods, okay, which are owned or possessed by the seller at the time of the contract. Generic goods are not specifically identified. Specific goods are identified and agreed upon. Future goods are yet to be manufactured or produced. Contingent is where there's a contract of sale of goods, wherein the acquisition of which the seller depends upon a contingency which may or may not happen. Okay. Then you have your conditions and warranties. Okay. Condition is the very basis of the contract. That is the main purpose of the contract. Warranty is collateral to the main purpose. That is a subsidiary promise. Okay. We saw the example of your car and your seat covers. Estoppel is it precludes a person from asserting something contrary to what is implied by his or her previous action. What is the previous action? You representing yourself as, say, a seller. Okay. So the estoppel concept precludes you. You cannot deny that you are not a seller because you yourself represented yourself to be a seller or someone with the authority to sell the goods. Okay. Encumbrances, which burdens the title to a property, which means that you may not have the complete title. It is burdened. Okay. So encumbrance can be a loan, a lien, okay, an easement or a restriction that limits the title. Okay. Constructive delivery is when the person is in the possession of the goods. Symbolic delivery is by indication. Okay. You are not transferring the goods itself, but just a means of obtaining the goods. And lastly, you have a bill of lading, which is a document signed by a carrier. Okay. Which is the transport of the goods, let's say your ship or rail. Okay. Or the carrier's representative, and to issue to a consigner. Okay. Consigner is the shipper of the goods, the seller, that evidences the receipt of the goods for shipment to a specified destination and person. Okay. Person is nothing but your buyer. Okay. Carrier is, say, your ship, your railway. Okay. Consigner is your seller. Okay. Consigner is your seller, and the person to whom it is to be delivered to becomes your buyer. All right. So with this, we have come to the conclusion of your chapter of sale of goods. All right. I hope you have been able to understand all of the topics that we have discussed in this. If you have any doubts, please feel free to reach out to us on our WhatsApp group. We would be more than happy to help you out. All right. So we've completed this chapter. We will also be starting off with the next chapter, which is that of your negotiable instruments. All right. But before that, let's quickly take a 5 to 10 minutes break. So let's meet. It's 12:55 now. Let's meet at 1:05, and we will start off with the next chapter, which is that of your negotiable instruments. All right. I hope you all have a good break. See you in 10 minutes. All right, great. I hope you all had a good break. So now let's begin with the next chapter that we have, which is our Negotiable Instruments Act of 1881. All right. So before we proceed into understanding the technicalities of it, let us understand the base concept first. Okay. So now let's say, for example, you are entering into a business. Okay. You are entering into a business. Okay. And you are entering into a transaction with someone else. Okay. So you have to make a payment. Correct, you have to make a payment. All right, so what is the primary most sought after method of payment? Cash. Okay, what is the primary most sought after method of payment? Cash. All right, but do you think cash is always safe? Okay, is it always safe? Sometimes not, right? Whereas there is a risk of theft. Okay, when it comes to cash, there is a risk of theft because anybody who owns that particular cash, right, becomes the owner of the cash, right? There is no name of a particular person written. All right, there's no legality written on it. Any person who has that particular cash, let's say a note, will become the owner of the note. So with your cash, there's a lot of theft that is involved, right? And it is difficult to manage. Okay, difficult to manage, especially large amount. Okay, difficult to manage, especially your large sums. All right, so that is when, okay, that is when back in the day when trades started happening. All right, people started shifting from the cash method of payment. All right, and they introduced the concept of these negotiable instruments. Okay, they introduced the concept of these negotiable instruments wherein traders, instead of having to travel using cash, okay, because cash carries the risk of theft. All right, so traders with actually not carrying your cash started carrying these instruments which promised payment, okay, which held some value in the eyes of the law. Okay, that is exactly where the concept of your negotiable instrument started coming in. All right, I'm pretty sure you must have heard about the concept of your check. Okay, you must have seen your parents depositing a check. Okay, someone issuing a check to you. All right, so that is a check, again, is a type of a negotiable instrument. So when you are presenting a check to someone, are you giving them physical cash? No, right? You are giving them a check, which is an instrument which guarantees payment to them of a certain sum to a specific bank account, right? So that is how your Negotiable Instruments Act came into picture. And in India, the act governing these negotiable instruments is the Negotiable Instruments Act of 1881. Okay, Negotiable Instruments Act of 1881, and that is exactly what we will be studying and starting off to study in today's class. All right, so let us begin now. So the foundation is that of your Negotiable Instruments Act of 1881. Okay, so the law governing negotiable instrument is primarily enshrined in this act. This act provides the legal framework for creation, transfer, enforcement of these crucial financial instruments. All right, so now as per this act, there are three basic negotiable instruments that are there. All right, this is something that we have already studied and had a look at when we were discussing our previous chapters, but in this chapter we will be discussing and understanding it in detail. Okay, so the different types of negotiable instruments that are there under this act, starting with your promissory note. Okay, promissory note, you have a bill of exchange and you have a check. Okay, before we even go ahead and understand the technicalities of this, okay, let us understand it with an example. Okay, let us understand it with an example. Okay, so the first one that you have is your promissory note. Okay, first one that you have is your promissory note. All right, the next one that you have is your bill of exchange, and the third one that you have is a check. Okay, let us now understand this one by one. Okay, so when I am saying promissory note, okay, let's say for an example, okay, let's say for an example, B buys goods worth rupees 50,000 from A. Okay, B buys goods worth rupees 50,000 to A from A. So B has to pay A 50,000. So what will B write? Okay, B will write, I promise to pay Miss a sum of rupees 50,000 on say a particular date. Okay, say on 31st of March 2026. Okay, so what are you able to identify here? Okay, what are you able to identify here? You are able to identify a promise made by whom? Made by B to whom? to A, okay, to do what? To pay 50,000 rupees on a specific date, all right. So you are able to see here that there are two parties, correct? There are two parties, okay. Who are the two parties? You have the promisor, okay. Who is the promisor in this case? B, okay. Then you have the promisee. Who is the promisee in this case? A, okay. So you have B as your promisor and then you have A as your promisee, all right. So B is the promisor who is promising to make a payment to A, all right. In this case, who will be the payer? Payer will be B itself because B himself has to pay. Who will be the payee? A. All right. So this is the concept of a promissory note where it is a written promise. Okay. It is a written promise to pay a certain sum of money to a particular person on a particular date, and promissory note consists of your two parties. Okay. So here promissory note, the maker itself is the payer. Okay. Please make sure that you understand these differences. The maker itself is the payer. Okay, maker itself is the payer. Okay, because I am promising to make a payment. All right. Now, when we go to bill of exchange, okay, when we go to bill of exchange, what happens in this case? Okay, in this case, instead of B promising to pay A will order B to pay. Okay, A will order B to pay rupees 50,000 on 31/3/2026. It can either be to himself or any other person. Okay, it can either be to himself or any other person. Okay, now in this case, what has happened? In this case, there's a promise to pay. In this case, you're ordering someone to pay the money to either you or some other person. Okay, one additional step comes in here is that B needs to accept it. B needs to accept it. Do you think acceptance is required in case of your promissory note? No. Why? Because the payer itself is promising, all right? But in case of your bill of exchange, acceptance is required. Why? Because you're ordering someone to make the payment, okay? You are ordering someone to make the payment. And for the bill of exchange to become valid, acceptance is required, okay? So now, let us understand who are the parties, okay? So there are three parties in the case of your bill of exchange, okay? You have your maker, okay. Who is your maker here? Your A, okay. Maker or your drawer, okay. Maker or your drawer, okay. Then you have the drawee, okay. Then you have the drawee. Who is the drawee here? Drawee is B, okay. Who will also be the payer? Yeah, because B will be the one paying. And then you will have the payee, which can be the maker itself, okay. Which can be the maker itself, that is A, or any other person. Or any other person. All right. So I hope you are able to understand that there is two parties in your promissory note, three parties in your bill of exchange. All right. So now let us identify the elements. Okay. So you have A will order. So A is the maker or the drawer. They're ordering B. So B is the drawee to pay. Okay. So payer as well. Okay. To pay a fixed sum on a specific amount to A, who is again the payee, or any other person. If any other person is there, any other person becomes the payee. Okay. Additional condition is that B needs to accept it. All right. So this is a bill of exchange. So promissory note is a promise to make a payment. Bill of exchange is an order to make a payment. All right. Then comes in your check. Okay. Then comes in your check. A check is a type of bill of exchange itself. Type of bill of exchange, and it is specifically drawn on a banker. Okay, it is specifically drawn upon a banker. All right. So it is, let's say, for example, B has to make the payment to A. Okay. So B orders the bank to make payment to A. Okay, so when I am saying B orders the bank to make a payment to A, okay, it is not a written order. It just means that B issues a check. Okay, B issues a check. Okay, so the minute B issues a check, okay, his bank will have to deduct that amount and make that payment to A's account. All right. So it means that B issues a check wherein B's bank will be responsible to make the payment to A. Okay, so what are you seeing here? In this case, what you are seeing is that Your B is the drawer, okay? Your bank is the drawee as well as the payer, okay? A is the payee, okay? So your check is always drawn on a banker, okay? Your check is always drawn on a banker. And here one more important thing is that no need for acceptance. No need for acceptance. Why? Because it is your bank, you are authorizing it to do already. The bank should not require any acceptance. All right, so I hope you are clear with these three topics that are there, which is your promissory note, your bill of exchange, as well as your check. All right, so promissory note, there's a promise to pay, there are two parties that are involved. Bill of exchange, there's an order to pay, the drawee should have accepted it, and there are three parties involved. Check is a type of bill of exchange which is always drawn on a banker, and no acceptance on the banker's end is required. All right. So I hope you are clear with the base concept of all of these three different types of negotiable instrument. If you are clear with this, the topics in the chapter become very easy for you to understand. All right. So now let's start one by one. Okay. Let's begin with understanding the chapter. So assuming all of you have understood these three types. Okay. So promissory note is a written promise to pay a specified sum of money. Okay. Promissory note is a written promise. Okay. Please make sure to focus on the written. Okay. Written promise to pay a specified sum of money. Bill of exchange is an unconditional order to pay a certain sum of money. Promise is written. A bill of exchange is unconditional order. A check is a bill of exchange drawn upon a specified banker payable on demand. Okay. Now it is important to note that the act does not affect indigenous instruments like hundis, which are governed by custom. Okay. So your act, your Negotiable Instruments Act specifically covers these three types of instruments, which are your promissory note, your bill of exchange, as well as your check. All right. Now, let us proceed to understand the meaning of your negotiable instrument. Okay. So your negotiable instrument is an instrument transferable from one person to another, embodying a right to receive the money. Okay. So it is an instrument which is transferable from one person to another. And that instrument contains what? It contains a right to receive your money. All right. So what are your key aspects of your transferability? Okay. So as per section 13, subsection 1 of the Negotiable Instruments Act, a negotiable instrument is defined as a promissory note, bill of exchange, or a check which is payable either to order or to the bearer. Okay. What is order and what is bearer? Okay. Order is when it is payable to a specific person. Okay, when it is payable to the specific person. Bearer is when it is payable to the holder. Okay, let's say for example you are issuing a check. Okay, if the check is blank, okay, then the holder, anybody who holds the check, can go and encash the amount. Okay, but if the check has the payee's name mentioned, pay name is mentioned, then it becomes order. That is, you pay to the order of that person. All right. So that is what negotiable instrument stands for, which is it is a transferable instrument embodying a right to receive the money. And for transferability, you need to understand that it is payable either to on order or on bearer. All right. Conditions of your negotiability. First thing is that you need to ensure your valid transfer. Okay, for an instrument to be truly negotiable, certain condition must be met. The first one being the instrument must be capable of being transferred without undue restrictions. We'll get to understanding the concept of transfer in the chapter. Taken for value, the transferee must have acquired the instrument in exchange for consideration. Right, there should be some amount of money involved which will add value to your negotiable instrument. Right, taken in good faith. The transferee must have acted honestly and without the notice of defect in any transferor's title. Okay. Now let's say, for example, in our example itself, let's just go back to our example. Okay. In this example, it says A will order B to pay rupees 50,000 to A. Okay. So now A can transfer the bill of exchange. Okay. Okay, A is the payee. Okay, A is the payee or the receiver of the money. So A can transfer the bill of exchange and say, instead of me, make the payment to D. Okay, make the payment to D. Okay, and this whole process is known as endorsement. Okay, This whole process is known as endorsement, wherein the receiver of the money in case of your negotiable instrument transfer it to another person. All right. So what we were discussing now is that of the good title, right? That only if you have good title, you will be able to transfer the negotiable instrument. Okay. But if the transferor does not have title and still transfers it, then the transferee will be protected. Why? Because if they have acted in good faith, then the transferee is going to be protected. All right. I hope you are clear with the concept of transferability of your negotiable instruments. Okay. Benefits of the transferee gets good title despite a defect. So if D did not know that A is not the actual owner, then D will still get good title. Transferee can sue in the own name. Okay. Then elements of negotiability and other instruments. Okay. So the distinctive characteristics that may be by delivery or endorsement plus delivery. Okay. So in case of your negotiable instruments payable to your holder, your delivery is possible. Okay. In case of your bearer, in case of your order, endorsement is required. So holder or bearer delivery is sufficient, but in case of order, your endorsement is required. Okay. Other negotiable instruments, they are by custom itself, that is beyond your Act of 1881. Okay. Beyond those defined in the Act, certain instruments can be considered negotiable if they satisfy your customary trade practices, right? So they're freely transferable by the custom. Holder in good faith gets defect free title. Holder can sue in his own name, and negotiability continues to maturity. So it does not deem these as non-existent or deem these as invalid, but it just says that it will be valid if they are following the rules of the custom based on which they have been created. All right. Next, the profound effect of negotiability. Okay, so nemo dat quod non habet. Okay, we just saw this, that no person will be able to give more title that they already have. Okay, but negotiable instrument is an exception to it. Okay, negotiable instrument is an exception to it, wherein this means a transferee can acquire better title than that of a transferor. Okay, so even if the transferor did not have the title and the transferee acted in good faith, the transferee will get the good title. Okay, bona fide holder for value. Such a holder who is acting in good faith and for consideration obtains a superior title to the instrument even if there was a defect in the previous owner than the title. So they have better title than the transferor. Why are we saying better? Because the transferor did not have the title itself, yet he transferred it, and now the transferee has good title to it. All right. So please make sure that you are remembering that your negotiable instrument is an exception to the fact of your nemo dat quod non habet. All right. Next, what are your characteristics? Okay, your holder is said to be the owner. Okay, your holder is presumed to be the owner, that the person in possession of the instrument is presumed to be its rightful owner. Freely transferable from one party to another. Defect free title, a holder in due course acquires a title free from any prior defects. Okay, can sue in own name. The holder has a legal right to enforce payment in their own name. Transferable till maturity. So that is, if there's an instrument due date, okay, let's say the promissory note, I am saying I promise to pay you, say 50,000 on 31st of March 2026. So 31st of March 2026 is the maturity of the promissory note, right? So it is transferable only till your maturity, not after the end of the maturity. Let's say in case of check, there's a default timeline for maturity, which is 6 months, okay, post which the check will become stale. Okay, presumptions will apply, that is, certain legal presumptions exist unless proven otherwise, simplifying your enforcement. All right. Now, classification of your negotiable instruments. Let us understand the different types and categories, starting with your bearer ones. Okay, bearer ones. So payable to bearer when express to be payable to the bearer or last endorsement is blank. Okay, so bearer is nothing but your holder. Okay, holder can obtain payment. What is last endorsement is blank. Okay, let's say A was the payee. A has endorsed it to C, that is, C will receive the money, and C makes a blank endorsement. Okay, and C makes a blank endorsement. So in this case, this becomes a bearer instrument. Okay, bearer instrument. That is, earlier you specifically had it on order. Okay, earlier you specifically had it on order, but now the endorsement is blank and hence it has become a bearer instrument. All right, bearer instrument is wherein the payee is not named. Okay, bearer instrument is wherein the payee is not named. All right, so whoever is the holder becomes the owner. Okay, whoever is the holder. So in bearer instrument, your holder is of utmost importance. All right, so bearer instruments are the ones which are payable to bearer when it is specifically mentioned that it is payable to bearer, or your last endorsement is blank. In this case, your holder will obtain your payment. Okay, example, check payable to bearer is transferable by delivery. All right, we just saw transfer will be by delivery if it is a bearer instrument. It will be by endorsement if it is a order instrument. All right. Next, order instrument when it is expressly said payable to order or a specific person, but it must not restrict the transfer. Okay, pay to A or on order. Okay, so it is specifically told that you will pay to A or on order. So which means that because a person is specifically mentioned, you need your endorsement in addition to your delivery as well. All right. Next, inland instruments. Okay, inland instruments are any instruments which are drawn or made in India and also payable in India. Okay, so drawn as well as payable. Drawn as well as payable, both are in India itself. Okay, an instrument is considered an inland instrument if it is drawn and payable in India and on Indian resident. Okay, even if it is payable abroad. For a promissory note, it is considered inland if it is payable in India only. So abroad, if it is payable, then it does not become an inland promissory note. Okay, so what is an inland instrument? It is an instrument which is drawn and is also payable in India itself. Okay. Next, you have your foreign instruments. Okay. Next is your foreign instruments where instrument is not inland. Okay. Which means that it is drawn outside India, payable inside or outside India, drawn in India, payable outside India. Okay. So either one. Okay. It should either be, okay, it should either be drawn or payable outside India. Okay, the minute any one of this comes in, it becomes your foreign instrument. All right, inland instrument is drawn and payable within India. Foreign instrument is either drawn outside India or payable outside your India. All right, next. Demand instruments. Okay, demand instrument, as the name suggests, no time period specified, but is payable demand. Okay, so whenever the person presents the negotiable instrument to you, you will have to pay this. So you see a pay now thing here. So which means that the minute it is presented to you for the payment, you are liable to pay it. Why? Because you have not specifically mentioned any time period. All right. So when we're discussing the example of the promissory note, we saw I will pay you so and so some amount on 31st of March. Okay, that is not a demand instrument. Why? Because your time period is specifically mentioned. All right, where in cases where your time period is not mentioned, it becomes a demand instrument. That is, your payment will have to be paid the minute your negotiable instrument is presented to you. Okay, then we have your time instruments which are payable at a future time. Okay, either after fixed period, after sight, on a specified day, or a certain event as well. Right, what could be your event? I will pay you 1 lakh rupees on the date of your wedding. All right, after sight is, in case of promissory note, is after being shown to the maker, bill after acceptance, noting or your protest. All right, so time instruments is basically which is payable at a future time. Okay, exact opposite of your demand instrument wherein no time is mentioned. So your time instruments can be paid, say, after a fixed period, after sight, on a specified day, on happening of a certain event. All right, then ambiguous instruments. Okay, ambiguous instruments is once chosen, the decision is final. So option remains with the holder. Okay, the option remains with the holder whether to treat it as a bill, whether to treat it as a note. Okay, so what is ambiguous? Ambiguous is there is lack of clarity. Okay, ambiguous basically means that there is lack of clarity. So the option is with the holder. Okay, the option is with the holder to decide whether it is a bill or whether it is a note. Okay, it can be treated as a bill of exchange or promissory note. The option is with the holder itself. Okay, examples, your drawer is your drawee itself. So drawee, fictitious or incompetent. Bill is addressed to no one. Okay. Promissory note addressed to third person. Okay. Promissory note are usually accepted to the second person itself. But in case of third person, once you have chosen, you cannot change. Okay. Once you have chosen, you cannot change. What is not ambiguous? When your drawer himself is your payee. So if you are drawing the instrument and you are only the payee, then the instrument will not set to be ambiguous. All right. So ambiguous instruments are those kind of instruments which gives an option a holder to decide whether it is a bill of exchange or a promissory note. All right. Next, incoherent or your incomplete instrument, all right, which means that it is a valid instrument but some technicality is missing. All right, so let's say for example you issue a check. All right, so if you have seen a check earlier, you must understand that your sign is very important for the check to be deposited. All right, let's say that sign is not there. That's what makes the instrument incomplete. All right, so incoherent instrument or incomplete is something which is signed and delivered but is blank, incomplete but stamped. Okay, holder, you have to make sure that the holder has authority to complete your instrument. The amount is lesser than your stamp value. And if there's a liability, it is to be to the holder in due course to the full amount. To ordinary holder, only your intended amount. Okay. So signed blank check, holder fills amount within the stamp limit. All right. So if you have a blank check, okay, when does it become complete? Okay. When does it become complete? When the amount is mentioned. All right. So incomplete instrument is basically any instrument where certain technicality is missing. All right. Next, kind of negotiable instruments. Okay, so we already saw the different types of negotiable instruments. Now we'll understand the three types of negotiable instruments that we just spoke about prior to starting with the chapter. Before that, let's quickly go to the module to understand whatever we have discussed so far. Okay, so this is our chapter 6, which is elements of law relating to your negotiable instruments. Okay, so we understood the definition of a negotiable instrument. All right, that is, it is the instruments which are covered in a Negotiable Instrument Act 1881, and it consists of your promissory note, bill of exchange and checks. Okay, it does not affect any instruments which are used as per custom or local usage. Okay, negotiable instrument is a document which is transferable to one person to another. Okay, and it consists some value for money. Okay, that is instrument, the property in which is acquired by anyone who takes it bona fide and for value notwithstanding any defect of title in the person from whom he took. So let's say notwithstanding any defect, as in if there's any defect in the title by the previous person, the person whom it is transferred to, the transferee will not bear the loss for it. Okay. Follows an instrument cannot be negotiable unless it is in such trade that the true owner could transfer the contract or engagement by a simple delivery of your instrument. Okay, by a simple delivery of your instrument. Okay, so your conditions for negotiability is that it should be freely transferable. Okay, good faith. Okay, and then they can sue for the instrument in their own name. Okay. Now, Act only recognizes three types. So you have promissory note, bill of exchange, and check. Okay. But it does not mean that other types are invalid. It just means that they must satisfy negotiability, but they are not bound by the Act. Okay. So the instrument should be freely transferable by custom or trade. Transferability may be by delivery. Okay. This is in case of your bearer instrument. In case of your endorsement, it is your order instruments. Okay, the person who obtains it in good faith and for consideration gets it free from all defects. Okay, so that is transferee can have a better title than who? Than the transferor. Okay, holder has the right to transfer. Negotiability continues till your maturity. All right. Effect of negotiability. Okay. So the general principle of law relating to transfer of property is that no one can pass a better title than itself. So nemo dat quod non habet. All right. We just studied this in the Sale of Goods Act as well. The exception to this general rule arise by the virtue of state or by custom. Okay. Negotiable instrument is such exception. That is a bona fide transferee. Okay. Without notice of any defect in title acquires the instrument free of defect. Okay, that is, he acquires a title better than that of the transferor. Why are we not saying same title? We are saying title better because transferor did not have the title, but you are getting the title. All right, very, very important concept for you to remember. Okay, important characteristics: holder is presumed to be the owner. They are freely transferable. Okay, Holder in due course gets the instrument free from all defects. They're entitled to sue in their own name. It is transferable till maturity, and in case of check, till it becomes stale, which is your 6 months. And certain equal presumptions are applicable to all negotiable instruments. All right. Then we went on to understanding the classification of your negotiable instruments, starting with the bearer one. Okay, where the last endorsement was blank, or it is specifically mentioned that it is payable to a bearer. Okay, order instrument when it is payable to a specific person. Okay, inland instrument is one which is drawn, made in India, and also payable in India itself. All right, drawn and payable in India, drawn in India or upon certain residents in India, but it is payable in a foreign country as well. Okay. Then we saw our foreign instruments, which is not an inland, basically drawn outside India, payable outside India. Okay. Demand instrument, where there's no time payment for demand, but upon presentation, you should be able to make the payment. Time instrument is payable at some time in the future. Okay, that is after a fixed period or at site or a specified day or of the happening of an event. All right. Ambiguous instrument is the one which may be treated by the holder. So the holder has the option whether to treat it as a bill and treat it as a note. And once the holder has decided, they will not be able to go back from it. All right. Then you have your incoherent or your incomplete instrument. Okay, when one person signs and delivers to another, properly stamped in accordance with law, and either wholly blank or having written thereon an incomplete negotiable instrument, he gives prima facie authority to the holder thereof to make it complete, as the case may be, upon it a negotiable instrument for any amount specified therein, and not exceeding the amount covered by the stamp. All right. So let's say if you're issuing a blank check, you can write the amount on it and make it a complete check. All right. The authority to fill up a blank or incomplete instrument may be exercised by any holder and not only the first holder. All right. Please make sure that you are understanding this thoroughly. Okay. So I hope you have been able to understand and go through this. Go through all of the topics that we've just discussed. If you have any doubts, please feel free to put them in the chat box. We will be more than happy to help you out. All right. So now just allow me a minute before we start off with the next topic, which is our kind of negotiable instruments. All right, great. Let's proceed with understanding the different kinds of negotiable instruments that are there, starting with your promissory note. All right. So since we have already understood the base concept, all of these details are going to be very easy to understand. Okay. So firstly, we have our promissory note, which is an instrument in writing. Okay. Please pay attention on the fact that your writing is something which is specified. Okay. So if it means that if I made an oral promise, Okay, if I made a oral promise to pay someone, okay, it is not going to be qualified as a negotiable instrument. Okay, it is not going to be a negotiable instrument. All right, so an oral promise to pay does not qualify as a negotiable instrument. All right. So promissory note is an instrument in writing which contains an unconditional undertaking to pay. All right. Please focus on the fact that it is saying unconditional. Okay. That is, it should be pretty direct that I promise to pay you this sum on so and so date to this person. Okay. You should not be like, I promise to pay you if this happens. I promise to pay you if that happens, right? There should be no condition to make that payment. Okay. It should be signed by the maker or also known as the drawer. Okay. Or also the payer, because they'll actually be the ones paying the amount. Okay, to pay a certain sum of person, a certain sum of money to certain person, order, as well as the bearer. All right, so I hope you are understanding the technicalities of your promissory note, which is an instrument in writing which contains an unconditional undertaking to pay. Please focus on these two words, that is writing and unconditional undertaking, all right, which is signed by a maker to pay a certain sum of money to a person, order, or a bearer. It is not a bank note. It is not a currency note as well. Okay. Next, who are the parties? Okay, the one is a maker, okay, who promises to pay. Okay, then is the payer who receives the payment. Holder can be the payee or the endorsee. So your payee can be the holder or the endorsee. Endorser is the one who transfers. Endorsee is the one who receives the transfer. Okay. Let's say, for example, okay, B promises to pay A rupees 50,000 on 31/3/2026. The same example that we took. Okay. Now, who is B? Okay, who is B in our case? B is the maker, correct? A is the payee or also the holder. Okay, now next, if A, okay, now let's say, for example, A also has to pay 50,000 to C. Okay, so what A does, A tells that instead of me paying 50,000 to C, I will transfer this promissory note to C itself. All right, so A endorses it to C. Basically, B will make the payment. B will make the payment to C. Okay, so in this case, your A becomes your endorser. Okay, and C becomes your endorsee. All right. So I hope you are able to understand this with an example saying who are the parties to a promissory note. So in the base, you have two parties, which is your maker and your payee. But when your endorsement comes in, you have your endorser as well as your endorsee. Okay. Then essentials of your promissory note. First thing, writing express promise to pay. Okay, example, I owe you rupees 500 is not valid, right? Because you are not telling whom you will make the payment to. You are not telling the date on which you are going to make the payment, right? So I owe you rupees 500 is a simple statement and it is not a promissory note. All right. Next, it must be unconditional. Okay, that is, conditional promises are invalid. Okay, when able to. I will pay you rupees 50,000 when I am able to. No, that is not a promissory note. Why? Because there's a condition of ability there. Okay, after marriage, there's a happening of an event, right? Valid if event certain to happen. Okay, but if you are sure, okay, after marriage, but you are sure the marriage is fixed on say 10th of April, right? Then it is okay. Then it is okay because you are 100% sure that the event is going to happen. Okay, pay 1,000 after the death of B. All right. Next, parties and signatures. It must be signed by the maker. The maker must be certain. I should not be like, someone will pay you rupees 50,000. I will pay you rupees 50,000, and the payee will also be certain. Okay, I will pay 50,000 on 31st March. To whom? You need to mention that very specifically. All right. Next, amount and payment. Amount must be certain. Okay, so I will pay you the best amount for this car. No, you should specifically mention amount. Or I will pay you the debt. I will repay the debt to you on 31st March. No, you need to mention specifically the amount, saying what is the amount that you are going to pay. Okay, so 100 rupees 100 plus other dues. No, so rupees 100 is certain, but the other dues is not certain, right? Which makes the promissory note invalid. Okay, must be payable in legal money only. So I cannot tell that I promise to pay you rupees 100 along with a batch of my goods as a compensation. No, you should be sure that you are including the exact amount that you are going to pay. Okay, formal requirements. So far what have we seen? Okay, so far it has to be in writing, it has to be unconditional, it has to mention the amount specifically. All right, your payer or your payer also should be certain. Okay, next are your formal requirement. It has to be stamped. That stamp should be cancelled. It should contain the place, date and number, okay, of the stamp. Omission does not invalidate. Okay, undated is, that is, your date of delivery is not mentioned. All right, so you need to make sure that all of these formal requirements are met for your promissory note to be valid. Okay, promissory note cannot be payable to bearer. Okay, so this is very important. So your promissory note, if I am saying I will pay 5,000 rupees to the holder of this person, right? Doesn't that make it look like a money, like your money in circulation, right? So promissory note is something which cannot be payable to a bearer. All right. Next is your bill of exchange. All right, so I hope you have been able to understand the concept of your promissory note. All right, so all of these characteristics are there, right there in the meaning of the promissory note itself. So if you have understood the concept, then you don't have to go ahead and by heart all of the characteristics. It becomes very simple and easy for you to understand. Okay, so now with the assumption that you have understood promissory note, let us begin with the next one, which is your bill of exchange. Okay, so bill of exchange again is an instrument in writing containing an unconditional what? Unconditional order, which is signed by the drawer, and it directs a certain person to pay. Okay, you are ordering someone to pay money, certain sum of money to a person, order, or a bearer. Okay, what is the nature? It is similar. Your rules are generally applicable, but the key difference is this is an order to pay and not a promise, right? You are not promising to pay someone, you are ordering someone to pay the money. All right. Next, who is the party to the bill of exchange? Okay, so now A draws a bill of exchange of rupees 50,000 on B to be paid to C on 31/3/26. Okay, now let us start identifying your parties. Okay, so the first one, drawer, is the one who draws the bill. Okay, so A is your drawer, correct? Drawee, the person on whom the bill is drawn. Okay, B becomes your drawee. Acceptor is the drawee who accepts. Okay, so B is also the acceptor. Payee is the person to be paid. C is the person to be paid or payee. Holder is the payee or endorsee. Okay, so in this case, C is the holder. Okay, now let's go a step ahead. Okay, so this is your basic bill of exchange. Now C endorses it to D. Okay, C endorses it to D. So it basically means that now the payment will have to be made to D. Okay, so C will not receive the payment, but D will receive the payment. All right. So what is C in this case? C becomes your endorser. Okay, D becomes your endorsee or the holder, because B finally has the bill of exchange with him. All right, so this is how you understand who are the parties to bill of exchange. Okay, please do not go mugging up the different types of parties that are there in promissory note and bill of exchange. If you have understood the concept well, this will be very easy for you to remember. All right, so these are the parties in bill of exchange. All right, regularly, normally it's three parties: your drawer, drawee, and your payee. All right, the others are different names depending on situations that you can give them. Okay. Next, special parties, that is drawee in case of your need. Okay. In case of need, it is named for payment if it is dishonored. Okay. If your bill of exchange is dishonored, then whom will it be paid to? Acceptor for honor accepts bill to protect the honor of your drawer or endorser. Okay. Accepts bill to protect the honor of the drawer or endorser. Okay. Let's say, for example, your friend B wants to take a loan from bank. Okay, they want to take a loan from bank, all right, and they need a minimum of 1.5 lakh balance in bank account. Okay, they need a minimum 1.5 lakh balance in bank account. Okay, but they do not have it. Okay, so you become an acceptor of honor. Okay, wherein B draws a bill of exchange on you. Say you are A. Okay, to pay 1.5 lakhs. Okay, to B itself. Okay, so your drawer and payee are the same. Okay, the only person who is different is your A. Okay, that is B can give this bill of exchange to the bank as a proof that he has the capacity to receive another 1.5 lakh rupees. All right, so acceptor by honor. So A becomes an acceptor for honor where he actually does not pay. Actually does not pay. They may later go ahead and cancel this entirely. They actually do not pay. All right, they are just lending their name. Okay, they are just lending their name. All right, so acceptor of honor is someone who accepts the bill. All right, we understood in the beginning itself that bill of exchange requires your acceptance. Okay, so A accepts this bill. Okay, saying he will pay rupees 1.5 lakh to be on a specific date. All right, why? To accept, to protect the honor of B. Okay, essentials of bill of exchange must be in writing, should be an unconditional order signed by the drawer, parties must be certain, amount must be certain, and it must also follow all of the formalities that we were just discussing. All right. Next, now coming to the interesting part, how do you differentiate between a promissory note and a bill of exchange? Pretty simple. It is just the meaning itself, but put in a table form for you to be able to compare the two. Okay. Promissory note, there are two parties, maker and payee, the one who promises to pay, the one to whom the amount is paid to. Okay. Bill of exchange, there are three parties, the person who is making the order, to whom the order is made to, that is the person who will pay. The drawer is also the payer, and the person to whom the amount will be paid to. Okay, the nature is a promise to pay. Here it is an order to pay. Okay, payee cannot be payable to the maker himself, right? Why? Because the maker is the one who is paying. Okay, maker is the payer, so maker cannot be the payee. Okay, here drawer and drawee can be the same person. This is a very important difference between the two. Okay, acceptance, no acceptance is required because the drawer himself is promising to pay. Okay, acceptance is required. Why? Because you are ordering another person to pay, and your bill of exchange becomes valid only if they accept that order to pay. Okay, liability is the maker's liability. Liability is the drawer's liability is secondary. Okay, dishonor, no notice is required. Why? Because you have promised to pay. In this case, notice of dishonor is required. No protest required. Foreign bill must be protested. Okay, bearer instrument cannot be payable to bearer. Okay, your promissory note has to be paid to on order, that is to a specific person itself, but in bill of exchange it can be payable to a bearer. All right, so I hope you have been able to differentiate and understand the differences between your promissory note and bill of exchange. So if you have understood the meaning, then identifying the differences between the two becomes very easy. All right. Next, origin of bill of exchange. How do you think the bill of exchange came into picture? All right, so it was originally used for your international trade payments. Okay, it was originally used for your international trade payments. Okay, avoided physical transfer of coins. So like I was mentioning, your theft was a threat that used to exist back then. So that's how your bill of exchange came into picture, right? Now used as your trade bills or your foreign trade bills. Okay, so just like how you have your inland promissory note and your foreign promissory note, similarly in this case you have your inland bill. Okay, which is drawn and made payable in India, or drawn in India, or a person resident in India. Okay, promissory note is inland only if drawn and made payable in India. Okay. Next, conditions for your inland bill. It must be drawn or made in India, must be payable in India, drawee located in India. All right. So example is drawn in India, payable in USA, draw in India. So what is important? What is important? Your drawn and drawee should be in India. Payable can be outside India itself, right? So this is the point wherein you need to pay attention to. That is, even if payable abroad, it is completely fine. Okay. Then you have foreign bills, the ones which are not inland, and they're usually drawn in sets of three. Okay, they're usually drawn in sets of three. You have a trade bill which is drawn for a genuine trade transaction. Okay, so A sells goods to B on credit, draws bill on B for payment. Okay, it requires your acceptance. Who will have to accept in this case? B. After acceptance, the drawer becomes your acceptor. Why? Because B has accepted to pay that amount to A. Then you have your accommodation bill, which is drawn without your consideration. Okay, which is purpose is to help or oblige another person. All right, it is the same example that we saw as in the case of your acceptor for honor. Okay, the same example that we saw in case of your acceptor for honor. Okay, so accommodation party is the one who lends name. Okay, so in our case it was A. Party accommodated, it was B. Real debtor is A, who receives the money from the bank. Who sureties are the ones who draw the bill. Okay, so liability, A and B originally have no liability at all. Okay, example, B and C draw a bill for A gets money from the bank, A is the real debtor. All right, in our case it was um, A draws for B. Okay, A draws for B and B gets money from the bank. All right. So I hope you have been able to understand the concept of your accommodation bill. All right. Last topic for today, given the time constraints that we have, is your bill in set. Okay, is your bill in set. So these are basically foreign bill drawn in sets of three. Okay, all parts together are one bill. Okay, payment of one, others become inoperative. Okay, so rules are basically that the drawer signs on all parts. Okay, all three parts. Stamp is on one part is accepted. Why? Because if all becomes accepted, it will become separate bills. Okay, if all becomes accepted, it will become separate bills. Okay, and right to duplicate your bill. If your bill is lost before your due date, the holder may request duplicate bill and only they can demand a duplicate. All right, so I hope you are clear with the concept of your bill of exchange and promissory note so far. Next up, we have bank draft as well as check, which we'll be understanding in detail in tomorrow's class. So tomorrow, being a Saturday, we will still have class. Only on the timings, we will come up with the link and notify you on the time. All right. So the module part of this, we will complete tomorrow before we start off today's class. All right. There's another class scheduled for today, so we'll have to end this class here. All right. But I hope you are clear with the concept of your negotiable instrument, the characteristics, the various kinds of negotiable instrument, and also the ones which are specifically mentioned in the Negotiable Instruments Act of your 1881. All right. So thank you so much everyone for joining today's class. I know we exceeded the time limit a little, but I hope everyone has understood all of the topics that we have discussed. All right. So we will meet you again tomorrow, wherein we will continue and start off with check and also complete the chapter. All right. Thank you so much everyone for joining. I will see you all tomorrow.